Right, welcome to this short session entitled An Introduction to Housing Conditions Claims. Just let me put the slideshow on. An Introduction to Housing Conditions Claims at 2022. I hope you found this session useful. There's been a real growth over the last 4 or 5 years, or a growth in interest in pursuing these cases. I've spent most of my working life in some way or other involved in these cases. Not during my age, but I very first did one of these cases when I was a trainee solicitor right at the end of 1979, which was probably before some viewers were born. And I then worked in the Vauxhall Law Centre in Liverpool in the early 80s, which was a centre that pioneered a lot of the cases in relation to housing conditions. And then throughout my 40 years as a solicitor, I've been involved in some shape or form, and in particular in the last 5 years, since I set up this consultancy business, I've spent most of my time training solicitors in relation to these cases and working alongside firms, helping them with issues of this arise. So what we're going to do today is we're just going to look by way of an introduction to these cases at what the landlord's duties are. So we're not going to get into technical details of litigating cases and settlement. They can be the subject of future sessions and also form part of the training courses that I do. But what we're going to look at today in the short session is explore what the landlord's duties are. So we're going to be looking at what is a housing conditions claim, what are the causes of action that a tenant has, what constitutes disrepair for the purposes of Section 11 of the Landlord and Tenant Act 1985, and in relation to more recent changes, what do we mean by fitness for human habitation? Just as a starting point for this, because I know that many of the solicitors that I've trained over the last few years have transitioned into dealing with this work, having previously dealt with general civil litigation work, and in particular personal injury work. First thing to know is you need to get into a different way of thinking for these cases. Housing conditions cases are based on the tenancy agreement, their breach of contract cases. And there's a very different way of thinking in these cases. So you do have to, as a start off, think differently. And the most fundamental difference is that the whole point of bringing a housing conditions claim is that you're representing the interest of a tenant who has been complaining for some time about disrepair which has not been done. And the idea of the exercise is to get the work done. And so you're seeking within the claim an order for specific performance. That's an equitable remedy whereby the court can order one party to a contract to do what they're supposed to do under that contract. These cases are based on implied, in the main, implied contractual obligations by the landlord in relation to repairs. So the main features of one of these cases, you have a tenancy agreement. Most are assured short-hold tenancies. Virtually all that you will deal with are assured short-hold tenancies, which have limited protection in terms of security of tenure, but do have the benefit of the repairing obligations. Most assured short-hold tenancies, in fact, in general, assured short-hold tenancies are 12-month agreements, and that will become relevant a little bit later on in this presentation. You also need an item of disrepair, and that's subject to various restrictions. You need sufficient notice given to the disrepair to the landlord in most cases. A failure by the landlord to rectify the disrepair within a reasonable time frame or at all, and you will have had damage or loss as a result. Which tenancies have the benefit of these repairing obligations? Well, Section 11 of the Landlord and Tenant Act, which is what we'll be looking at for the next half an hour or so, applies to tenancies of less than 7 years, beginning on or after the 24th of October 1961, which was when we first had these implied repairing obligations. There are some provisions for longer lettings, but you won't come across them very often in practice. Section 11 of the Landlord and Tenant Act 1985 is the bread and butter provision in relation to repairs to the structure of the property. And there's 3 core duties: to keep and repair the structure and exterior of the dwelling house, keep and repair and proper working order installations for supply of water, and installations for space and water heating. Little note there at the bottom. Obligation exists as long as the tenant does not cause the problem. Section 11 does say that there's no obligation on the landlord in relation to issues which have come about as a result of the tenant's failure to act in a reasonable tenant-like manner. So, for example, tenant comes home from the pub, kicks the front door in, he's going to be in difficulties then suing the landlord in relation to the disrepair of the front door. There are also more subtle arguments which is raised in that context in relation to things like condensation, which is an accumulation of moisture from within a property, and we will touch on that briefly a little bit later on. So first and foremost, you have to show that there's some disrepair. I mean, I'm going to spend a little bit of time now just unpacking what disrepair means. To be part of the structure, there has to be some material element of the building itself, and specifically includes things like gutters and external pipes. Just one example is the question of plaster. See, one thing Section 11 doesn't do is give a detailed list of exactly what items of repair are within the landlord's duties and which aren't. It's a very broad brush definition. It says structure and exterior, including drains, gutters and external pipes. And there's been litigation over the years, battleground over what actually constitutes the structure. And one classic case is Grant and Gill, which is all about plaster. So what happened in that case is the argument was, is plaster part of the structure or part of the decoration of the property? You have your bricks, and the plaster goes on the bricks. So the argument on the landlord side was structure ended with the bricks, and on the tenant side, well, no, you can't have a wall without plaster on it. And in that case, the decision was made originally as 2011 that plaster was a part of the structure and therefore within the landlord's obligations. And I just throw that in as an example that the law has developed over the years, certainly since 1961, in relation to what constitutes the structure and exterior of the property. There's just a few examples of things which do form part of the structure: partition walls, joists, roofs, etc., etc. And if it's decoration, it's probably excluded. That's a very broad brush pointer as to what might form part of the landlord's obligations. 2 other obligations. The second one is in relation to the supply of water, gas and electricity. That's the supply of those facilities to the property, not fittings that use the supply. So if there's a washing machine at the property, most cases it's probably the tenant's own washing machine anyway. If there's a problem with the supply of water to that washing machine, then that's the landlord's responsibility. Whereas the washing machine itself is defective, then that's normally the tenant's responsibility. And the third duty there is space and water heating. So this is to make sure things like boilers, gas fires, radiators, etc. are in proper working order. Now, under Section 11, there is what I call a low bar in this sense, is you have to show that the problem is at least having some impact on the tenant enjoyment of the property. So, for example, if you've got a few external cracks on the brickwork, but they're not actually having any impact in relation to the tenant's occupation of the property, then that probably comes within this. You will often come across these arguments in relation to cracks in ceilings and things. If it's just a minor crack in the ceiling, which all properties can suffer from, you're likely to be met with an argument that that's not actually impacting on the tenant's enjoyment of the property. There's a reference there to common parts, which I'll come to shortly. Okay, so you just have to get over that basic bar. Now, in actual fact, in reality, unless you can show that the cost of the repairs exceed 1,000, then it won't always be viable to bring one of these cases. And so that's probably going to get you across that bar anyway. So just so you know that it's not every single item of disrepair, there has to be some impact on the tenant's occupation. Section 11 also says regard should be had to the age, character and prospective life of the property. In other words, if it's a crooked house, it's a crooked house. And there's no obligation on the landlord to make it anything other than that. There's no duty to totally renovate old-fashioned properties. There's a reference there to a case from 2005 where the doors were twisted and windows were also bent. That wasn't a disrepair, that was just the way it was. It was commensurate with the age, character and prospective life of the property. The duty under section 11 is to do repairs. And one way of looking at this is this example here. I think it's fair to say that that property there is probably a good case under section 11. There's quite a few matters there, as you probably gather, which would come within duties in relation to the structure and exterior. But there's no duty under section 11 to demolish and rebuild or to completely renovate a property. The basic duty is to do repairs. So in the unlikely event that this roof could be repaired, then that complies with the landlord's duties. Even if you've got to come back next year and do it again and again, the duty is to do repairs, and it's up to the landlord to respond to that duty in whatever way they choose, because the duty is one to do repairs, and that can be a problem sometimes when properties might need extensive renovation, but that's not part of the duty to do repairs. I always say when I do my training that this is the most important slide of all. I've taken this quote from the Legal Action Group guide to housing conditions. In fact, there's a slight mistake on the slide there. It says repairs. It should be now housing conditions, tenant right. And we do now have the 6th edition. That's because of changes in the law that we'll get to shortly. But this is the classic definition of what constitutes disrepair. It is clear that repair is the converse of disrepair. There must be disrepair before the landlord is liable to repair. Disrepair occurs when there is a deterioration, i.e. when part of the building is in a worse condition than it was at some earlier time. Now, first reading, that looks like the most obvious statement you've ever heard, but in actual fact, when you drill down into the real world, it's really, really important that you understand the significance of that definition of repair. For something to require repair, it has to be broken, or it has to be in a worse condition than it was before. For example, if at the start of a case, you'll get a surveyor to have a look at the property, and they will, at the end of that, normally do a schedule outlining what repair is needed and what the cost of that repair will be. Now, it's really important that you look at that schedule, because I've seen surveyors' reports, and remember, surveyors are not lawyers. I've seen surveyors' reports which don't seem to follow that definition of repair. For example, you might see a report that says a bathroom in the property suffers from condensation, and you might pick that up because you'll see photos of sort of speckled black mold, etc. And the report might say, this bathroom has never had an extractor fan and one should be installed with the price, but that's not repair. Nothing is broken there. There isn't an extractor fan there in the first place. There's no duty under Section 11 to fit something which isn't already there. The duty is to repair something which is now in a worse condition than it was. So if you've got an extractor fan that doesn't work, then the landlord's duty is to repair it. If there's never been one, under Section 11, there's no duty to put one in. And it's really important that we understand that concept of disrepair, because as I've said before, these cases are often not viable unless the cost of those repairs are likely to exceed £1,000. And this is because of the rules on allocation to the small claims track. And so if in that schedule items are included which would appear to get you over that hurdle, but in actual fact are not actionable as such, then that can give a misleading figure. So it's really, really important when you're looking at your reports, don't just do what some do, and in fairness, what I do, go straight to what I call the sports page and look at your bottom line figure. You have to analyse what's recommended so that you can be sure that within terms of Section 11, it's coming within that definition of repair. I always say, make sure when you're instructing your experts that they understand that concept. The duty is one to repair, not to improve. But good old Lord Denning did explain in this old case from the 1950s some qualification of that. Because what he says is, if you've got something that's so worn out, so dilapidated, that in actual fact it can't be repaired as such, and the only way you can effect a repair is to put something new in, then that's not an improvement, that's a repair. So for example, let's say you've got an old window frame and it's completely wrecked, and there's just no way anyone is ever going to actually be able to repair it as such. Then that's in disrepair. If we go back to the previous slide about the definition of disrepair, that's in a worse condition than it was at some earlier time, so repair is needed. But in actual fact, the only way to effect that repair is to put a new one in. Well, what Denning is telling us in that case is that is in actual fact how the repair itself is effected. Section 11, again, and I'm labouring this point, but it's really important to understand this, is about repair. You may sometimes come across properties with design defects, particularly, and again, condensation raises its head so often in these cases. There may be properties which were designed in a certain way in the 60s and 70s, but are now less effective just because of the different lifestyles that we now live. And those design defects might cause problems, but they don't within themselves create a need for repair. And there's a case here called Stent v. Monmouth, where there was water penetration, but it was caused by a design defect, an inherent defect. And so that was outside Section 11. What then happens is it then reached a stage where there was developing disrepair. So it might have been a design defect, but as a consequence, a Section 11 disrepair problem arose. Well, from that point on, then it was within the landlord's duties. So for example, let's say you've got a property that suffers for condensation due to design defects, then that's not Section 11. If it gets so bad that the plaster starts falling off the wall, well, we know the plaster comes within the landlord's responsibility. So insofar as it's then impact on the structure, then it sort of develops into an issue which the landlord has to deal with. There are some obligations on tenants, and most of these are common sense. So the tenant has to act in a reasonable tenant-like manner, and you'll see the reference there. So this is going back to what we said at the start, that if an element of the disrepair is caused by the tenant, then that falls outside the landlord's duties, and I gave a simple example of that. And again, one common argument which you will come across, especially in the old chestnut problem of condensation, is some landlords will say that the reason why there's condensation in this property is because the tenant has not acted in a reasonable tenant-like manner, and they will use arguments like they should open all the windows, they should keep the heating on. I have to say, I'm always a bit skeptical about whether a tenant on the 15th floor of a tower block in December can be expected to have the windows open, and especially in a current climate where fuel prices are going through the roof. Is it unreasonable for a tenant not to keep all the windows open? Sorry, that's a separate rant, but it's an example of where you'll get arguments that tenant has not acted within their obligations. Tenants must allow the landlord access to the property subject to restrictions. This is a well-established principle. I've quoted the reference to this, the Rent Act. The Housing Conditions Protocol also makes reference to it. Tenants can't prevent the landlord coming in to do repairs. And if you're running one of these cases and there's a dispute between you and the landlord's lawyers and experts about what's needed, and landlord says, well, we're going to do the work that we accept, you can't physically prevent them from doing it. It's an obligation under the tenancy agreement. And also tenants have to do those reasonable sort of day-to-day maintenance jobs that any reasonable tenant would be expected to do, such as changing fuses, unblocking sinks, etc. So there's the duties under Section 11. And the main point I've banged on about is it's all about repairs. The next key question is, and in some ways more important question, certainly quite often a more contested issue, is at what point does the landlord become liable to do those repairs? And in the main, landlord will not be responsible for internal repairs, in other words, repairs within the property, unless they have notice or have some other form of knowledge of the need for repair. And this is such an important issue that we're just going to spend a few minutes exploring this in more detail. There must be sufficient notice to put a reasonable person on notice or inquiry about the problem. And we're going to start looking at internal repairs because there are different principles at play here. And the classic cases O'Brien and Robertson, which we will look at in a sec. But there could be actual notice, and this will be the bread and butter for cases that you deal with. What you'll be mainly focusing on is actual complaints which have been made by the tenants or others on the tenant's behalf about the disrepair. And you'll do that by way of a witness statement from the client, by gathering documents which the client might have in terms of emails, phone messages, or whatever. And probably most importantly, disclosure from the landlord of the housing file, which will contain details of complaints which have been made. When you come to send a letter of claim in one of these cases, you will normally follow the template which is in the pre-action protocol, and that includes in it a request for disclosure of these documents. This is all part of this essential building block in relation to notice, because it's absolutely central to triggering the landlord's liability. You can argue there are circumstances through which the landlord ought to have known about the problem. So what happened in O'Brien and Robinson, the facts are very straightforward. The poor claimants were in bed, the ceiling fell on them, causing injury. That claim ultimately failed, and it failed because there was no way, unfortunately, that either the tenants or the landlord were aware or could have been aware that there was a developing structural problem that was going to cause the ceiling to collapse. And Lord Diplock's judgment explores these principles as what you need to look at is, when does the landlord's duty arise? Is it always there? So the minute there's a problem, the landlord is liable? Or is that point, do you reach that point somewhere along the timeline? And the principle that came out of O'Brien and Robinson was, it's when the landlord knows that there's a problem and fails to remedy it within a reasonable time. Remember, we're focusing here on defect within the property, and we're just going to spend a little bit of time exploring that in more detail. But just before we do that, one question I always get asked when I'm doing these sessions face-to-face is that Lord Diplock says there has to be, the time arises when the landlord knows about the breach and then fails to carry out the work within reasonable expedition. Hands always go up. What do we mean by reasonable expedition? And I'm afraid the answer to that is, how long is a piece of string? Because this subject matter is so broad, you can't just pinpoint one item of disrepair and say that's how long it takes. In one sense, it would be great for us all and be very clear if we could all just find a big table somewhere and we could work our way through this table, look at the disrepair, the problem, the cost, and pluck a figure out of the air as to what's a reasonable time. In the real world, that's not going to happen. And in a lot of cases, you will need guidance from your expert. There is a very obscure provision, which I've put a link to there, which does give some idea of timescales for very basic, not so much basic repairs, but repairs which are easy to pin down. And so partial loss of electricity, 3 days, etc., etc. That's a handy guide to give us all some idea, but it's not particularly reliable, mainly because it's very rare that you would just have one of these. The nature of these cases is there's a combination of factors and they can all interrelate in terms of identifying what the reasonable timescale is for work. But, and we're still on this important issue of notice, the O'Brien and Robinson principle is that there has to be knowledge of defects to the internal part of the property. Complaints are not always essential for defect to the external structure. And there's a really interesting case here called Edwards versus Kurramasamy, which makes the point that the requirement for notice that we're talking about here is in fact an exception to the norm. And the reason for that is, if a tenant resides in a flat, he's got a legal right of exclusive occupation of that flat. The landlord does not have the right to come and go as they please to find out whether there's problems with the property. There are limited rights of access subject to notice, etc., which we'll look at later. But there's no general right to just come and go. So what that means is, if the landlord is not going to be able to be aware of the problem unless the tenant tells them, that's the point in that context when the liability arises, essentially because how else will the landlord know unless it's brought to their attention by the tenant? Situation's different in relation to some part of the external structure or part of the building which is outside of the specific area over which the tenant has got exclusive occupation. Really interesting quote here from Lord Newberger from Edwards v Kurramasamy, where he explains what the general rule is in law, that where a landlord or a tenant covenant to keep premises in repair, the general principle is that operators are warranted that the premises will be in repair. He refers to the Sunlight case and then says, accordingly, as soon as any premises subject to a covenant are out of repair, the covenanter is in breach, irrespective of whether he's had notice of the disrepair. So there's the general rule in contract law, is if the landlord's under an obligation to do repairs, the minute there's a problem, the landlord is liable. What we have in our cases here, in those cases where the tenant has exclusive occupation, is a rule which is an exception to that general principle, which is the rule that the landlord has to have knowledge. And Lord Newberger went on in Kurramasamy to say this: if a part of a structure included in the tenant's letting is out of repair, then the tenant is in possession of that part of the structure and the landlord is not. Accordingly, the rule, i.e. the rule that there has to be notice, would apply to the landlord's obligation to repair that part of the structure. However, if the part of the structure is excluded from the demise, it would not be in the possession of the tenant. Indeed, it would be in possession of the landlord, and so the rule would not apply. So this rule on notice is focused on those items of disrepair that the landlord can't know about unless they're brought to his attention. Other items of disrepair over which in areas where the landlord does have control, the duty is immediate. And so the sort of things we're looking at here, and it's normally going to be within say a flat or a masonette, which is part of a larger structure, and other problems within that structure and not in areas where the tenant has exclusive occupation. And therefore the duty is immediate. And that could be quite important because you have a flood due to a problem in part of the building which is under the landlord's control, then any damage suffered by that flood is immediately caused by a breach, and action can be taken to recover property that's lost and inconvenience. However, if it's within the area of which the tenant has control, then we fall back to the need to establish notice and reasonable time. And so you can see it's self-evident there that there's bound to be a time lag which would impact on the tenant's recovery. So I just want to emphasize that. And so you will have a difference here between the letting of, say, a flat, because part of the fabric of the building is bound to be outside of the tenant's control, and say a house. In the case of a house, it's the entire unit is part of the demise and over which the tenant has a control. So I just want to emphasize those principles. But I should say in the real world, 90% of case that you deal with, you are going to need to show some evidence that it's been brought to the landlord's attention. The burden to prove notice rests with the tenant. That's a general principle in English law, and it's up to the tenant to prove that on a balance of probabilities. That's the civil standard of proof. Tenant has to prove not 100%, not with 100% certainty, but on a balance of probabilities that the landlord knows about the problem. Doesn't have to be to the landlord themselves. It can be imputed knowledge via workmen, agents, caretakers, etc. In fact, anybody with some express or implied authority to receive a complaint, so long as it's a reasonable source. One example, the case of Denifa versus Jones, where the person who attended the property was the environmental health officer. He wasn't there over a housing issue, wasn't from the housing department, but insofar as he was able to view issues which came within the council's responsibilities, that counted as knowledge. So there was no obligation for him to then carry out a detailed investigation, but insofar as issues were apparent, then that counted as the council's knowledge. Brief mention about common parts, section 11A. One of the problems with the old section 32 of the Housing Act 1961, which was where all this started, and under section 11, when we first had it, was it says the landlord's responsibility is in relation to the structure and exterior of the dwelling house. Throughout the 60s and 70s, there was a development of multi-occupation properties, tower blocks, etc. And that rarely brought out a problem. What happens with those areas of those buildings which are actually outside the specific area of the dwelling house? That picture there will be well known to some people in Liverpool who are of a certain age. There's two, the other one's hidden, of 3 blocks which were known in Liverpool as the piggeries, for understandable reasons. And those buildings suffered from a number of common problems. One example of which was the chutes that we used to clear the rubbish, which kept being defective and therefore led to consequential problems in terms of infestation and smell and health issues. but who was liable for those common areas. And that was a real issue in a case called Erwin v Liverpool City Council, which was a case, the Vauxhall Law Centre, where I once worked, was involved in. And this all eventually led to an amendment to the Landlord and Tenant Act, Section 11A, in 1989, which extends these duties that we've been talking about, these duties of repair, to the common parts of the building. So it's not limited to the actual physical area let to the tenant. Any other part of the building over which the landlord has a control, those areas are within the landlord's responsibilities as well. So things like lifts, communal hallways, stairways, etc., are all included within these obligations. And that is a very whistle-stop tour through the landlord's obligations under Section 11 of the Landlord and Tenant Act 1985. And that's, throughout almost all of my time as a solicitor, has been the foundation of cases for housing conditions. In fact, up until recently, we all called them housing disrepair cases, because that was what they were, and there were real limitations unless the problem came within that definition. What we now have, and what we've had since the Homes Fitness for Human Habitation Act of 2018, is a new implied covenant on landlords, which has the potential to dramatically change things going forward. I say potential because it's relatively new law, and almost all the time, as we'll see, since this law came into force, we've had lockdowns, so not an awful lot of litigation, but these potentially add a new dimension to the landlord's duties to do repairs. What the Act does is create two new implied covenants by a landlord in relation to fitness. And what it does is create a new Section 9A of the Landlord and Tenant Act 1985. And it's an obligation under the contract that the property will be fit for human habitation at the time the lease is granted or otherwise created, and will remain fit for human habitation during the term of the lease. So two duties on the landlord to ensure the property is fit on day one and will remain fit throughout the life of the tenancy. We've actually had the expression fitness for human habitation for many years in all sorts of different contexts, particularly within express clauses in leases and some very old acts of Parliament. And there's even a reference in Section 8 of the Landlord and Tenant Act 1985, which is completely useless, and certainly all of my professional life has never, ever been used. And that's because it was an obligation to ensure fitness for human habitation in relation to tenancies on low rents. And the original purpose behind that was so that your very basic properties were at least fit for habitation. The problem is that those low rent limits had not been updated, certainly hardly ever in my lifetime, and the relevant rent in London was £80 per annum. Imagine trying to rent a property in London for £80 an hour, let alone £80 per annum. So Section 8 was useless, but it's part of a package of cases where the courts have explored in the past what we mean by fitness for human habitation, and so that's the only relevance of that, rarely. What tenancies are affected or have the benefit of the new Act? Well, it follows and in many ways mirrors Section 11. So it's tenancies of less than 7 years. Now, note, granted after the 20th of March 2019, these duties are not retrospective. So what that means is you can't put in a letter of claim a complaint about properties saying that they're not fit for human habitation for a period prior to these obligations coming into effect. That sounds obvious, but that is a common mistake that I've seen, and one that you do need to be aware of. Now, what then happened was that the idea of the new fitness principles were that they would be phased in over a period of time. Remember, I said at the start that most tenancies that we're looking at here are assured short hold tenancies, which are normally 12-month tenancies. And the fitness provisions, as I say, were not retrospective, and they came into force when a new tenancy was granted. Vast majority of tenancies, as I say, are assured short hold tenancies of 12 months. So the thinking behind that was that by the time we get to 12 months from the 20th of March 2019, i.e. 20th of March 2020, virtually every tenancy, residential tenancy, would have the benefit of these provisions. So in actual fact, most tenancies that you will deal with have the benefit of these principles from the 20th of March 2020. So it's pretty well everything now, and we're now 2 years on from that as well. But just a reminder that they're not retrospective. Okay. Just another couple of things tying this in with section 11. It refers to common parts in the same way that section 11 does, so that mirrors those disrepair provisions. There's no duty on the landlord to do works which the tenant is required to do because of his duty to act in a tenant-like manner, which is something we looked at before. No duty to rebuild or reinstate the property. And just a couple of other little exceptions. No duty to repair and maintain anything which the lessee is entitled to remove from the dwelling, so the tenant's own responsibility, and a couple of provisions there where you might need consent of a third party to do work in a part of the building, and the duty there on the landlord is to exercise reasonable endeavours to get that consent. One thing that's different about the fitness for human habitation obligations is that, unlike section 11, there is in fact a detailed help as to what can constitute or what can render a property unfit, and this is in the new section 10. Can I just say there that already now we don't talk about the Homes Fitness for Human Habitation Act 2018, although that's the source of these obligations. Because what that act did was amend the Landlord and Tenant Act 1985, creating a new section 9A and the section 10. So we now already just talk about section 9A cases and section 10 cases. And as we can see here, section 10 refers to certain factors which can render a property unfit. As you'll see here, and you can see that it's a fairly sort of broad list, and it carries on. An interesting reference partway down this slide was in relation to any dwelling in England, any prescribed hazard. We're going to explore that in a little bit more detail in a sec, but just to explain the reference to England is that none of these provisions that we're talking about are in force in Wales at the time I'm doing this video, which is April 2022. And so there are two separate protocols for these cases, one for England and one for Wales. And properties in Wales don't yet have the benefit of the obligations in relation to fitness for human habitation. That's all going to change by the summer of 2022. And the obligations in Wales will, in the main, fall into line with this, but that's the provision as of today, and that's why there's a reference in section 10 to dwellings in England. But there's a really important qualification to all of this, because section 10 lists all these factors which can render a property unfit, but it's not a tick box exercise. So you can't just look at the list and say, the problem in natural lighting, therefore the property is unfit for human habitation. The test is the other way around. You have to show that these factors, they can be taken into account, but the overall requirement is that you have to show that they're so far defective in relation to those matters that the property is rendered unfit for human habitation. And that's the overriding test, and that has to be the focus of your evidence. And again, we'll come and look at that in more detail in a sec. Prescribed hazards, these come from the Housing Act 2004. which created the Housing Health and Safety Rating System, which everybody calls HHSRS. 29 hazards there altogether. I've not listed all of them here, but included things like damp and mold, excess cold or heat, crowding, lighting, personal hygiene, etc. These are all factors which were part of the HHSRS created by the 2004 Act. The 2004 Act itself didn't create obligations which the tenants themselves could enforce. It created factors to be taken into account by local authorities in relation to them taking action to ensure decent home standards. What this does is it incorporates those hazards into the definition of what can render a property unfit for human habitation. So to that limited extent, it does now create a cause of action. But again, it's subject to that overall requirement to show that the property is not fit for human habitation. Little note of my own there at the bottom, is notice required? Yes, absolutely. These obligations in relation to notice that we talked about under section 11 don't appear in section 11, and there's nothing in section 9A either. And that's because these are common law requirements which are developed in relation to our law of contract. And it's all to do with what defects is the landlord aware of, and what defects could the landlord be aware of. And exactly the same principles will apply if there's no way a landlord can know about the problem unless it's brought to their attention. Then the notice principles will apply. Just a brief mention, and I did touch on it before, about landlord's limited right of access to the property. As I've said, the tenant has a right of exclusive occupation, and landlord can't come and go as they please, but there's a limited right of access at reasonable times of the day and on 24 hours notice in writing. So that's the very limited right of access that a landlord has to inspect the property for disrepair. Doesn't alter the overall provision that what would trigger the need for that, apart from some complaint by the tenant that have brought the existence of the disrepair to the landlord's attention. So just some thoughts on what we mean by fitness for human habitation. And for obvious reasons, we don't yet have authoritative guidance from the courts on what this means. That's partly because they came into force in March 2020, which corresponds almost exactly with when we went into the first lockdown. But we do have some guidance from previous cases, because, as I said before, the expression fitness for human habitation has been around for a while. So does the concept of a hazard. Remember the prescribed hazards. And the definition of a hazard under that act is something which involves a risk of harm to health and safety of an occupier of a dwelling. So I think that's the starting point. A property is unfit for human habitation if it, to some extent, raises a risk to the health or safety of the occupier. And we're helped here by a very old case of Morgan and Liverpool City Council from the 1920s. So this is almost 100 years old. Lord Atkin, if the state of repair of a house is such that by ordinary use damage may naturally be caused to the occupier, either in respect of personal injury to life or limb or injury to health, then the house is not in all respects reasonably fit for human habitation. So again, we see that need to produce evidence that it presents a risk of injury to life or limb or injury to health. So that's where we are in terms of saying what we mean by fitness for human habitation. Does the existence of the defect create that risk to health and safety of the occupier? So as I've said before, all those lists that we've got are helpful guides, but just because you tick one of those boxes doesn't give you a case of the Section 9A. The overriding test is, does that problem render the property unfit? And almost certainly the secondary test there is, does that therefore present a risk to the health and safety of the occupiers? And just before we finish, that does raise an interesting question on evidence. Who is qualified to say whether a property is unfit for human habitation? Surveyors are the experts of choice in housing conditions cases, but is a surveyor qualified to say if a property is unfit? They can comment on the structure, but they can't, or are they, is the question, qualified to say whether a property is fit for human habitation? May in some cases be self-evident, and that would be a question for lawyers and courts to decide. So black mold in a property that causes all sorts of health problems, and there may even be medical evidence that it has caused health problems, but that may well just lead to a finding that the property is unfit. There may be cases where evidence will be needed from an environmental health expert who have particular expertise in this area. And that's a development which I think we'll see develop as time goes on. Just a final word on resources. I mentioned the housing conditions book by the Legal Action Group. That's rarely is required reading, and nobody should even leave their desk on one of these cases without using that book. And I'm not on commission; it just really is that that essential. And I put a reference in there to a blog, Nearly Legal, written by Giles Peaker, who's one of the authors. And that blog really is an important resource, not just on these issues, but on all areas of housing law. And that is the end of that presentation. So I hope that that's been useful. If you have found it useful and would like to be informed of any future sessions, if you just have a look at, I think this is what you're supposed to do, the red subscribe button, if you give that a click, and I'll be putting a note in the comments about other forthcoming events. Thank you very much, and thank you for watching.